Hello, my name is Navjot Sangwan. My student ID is EGU8659. Today I am going to speak about ASIC versus Sino Gas Limited Company. So in this report, a case named ASIC versus Sino Australian Gas Limited Company was discussed. The case was filed by the ASIC against the director of the company, Mr. Shaw, and the director of his listing shares, ASX, Australian Stock Exchange, where the company has raised 13.6 billions. The director of the company had tried to take out the cash reserved to the China and thus triggered suspicion. The case was evaluated on the basis of where the selection of the Corporation Act listing rules. I am bringing the issues in light now. The first one defendant is Sino and Company, and the second one is Shaw. So the ASIC in his petition has claimed the following. The company had made false claims regarding to the patents that it is holding with the Chinese entity. The company had failed to disclose material information in its prospectus concerning the profit against the claims in replacement prospectus. The company had omitted the circular information relating to the loan agreement directors to the subsidiary entity. In the next issue, the company had provided the wrong information concerning it to be a contract that claim in the place of Chinese entity. That company had provided a wrong information to the auditor regarding to the Chinese entity. The ASIC says and Charles Shaw has failed to discharge his duties as director, whereas the selection of the corporation where the section of the Corporation Act 2001. So that's all about the introduction and the issues. Now my friend Robin gonna discuss more about this company.
Hi, my name is Robin and my ID is EGU8655. Now I discuss about the rule of the case. ASIC is the alliance of the company which is violating the section 728(1)(b) and the 728(1)(c) of the Cooperative Act. This act section is when any document is failed to disclosure. Section 728(1)(c) is applied here, and the section of any misleading in any document is the offense here. Further, this case is as per the rule of the company cannot offer any security if any material or a document which is changed is the violation the section 710, 711, 712, 713, 713E, 713C, 713D and 714 and 15. Further, this case is not if any new circumstances of rising than account after the filling the document, this person cannot issue any security. Further, this case is judged under the section 710, which give to any filled form must have all the information that is relevant to investor and the professional advisor. This is required to order to make the information about the material to extract which is the investor and the professional expert to find the information in any document to a person who have relevant knowledge. Further, this case judge under the section of discussion 3.1. It provides that once the entity who have any information or responsibility would expect to have material effect on the price of increasing the value of the any debt security. Further, this company is also judged under the basis of the 728(1)(a) delivered to the replace property which state a person or a company did not offer any security of any misleading to the statement. This is my part in this presentation. Thank you.
Hi, my name is Japinder Palkortillo, and I am a student of Business and Law Corporation. My student ID is EGU8658. I'm going to speak about the application today. The second rule here is 6.4(1) and 2, as well as the listening rule of 3.1 that state the company needs to share all the information that could be placed to price sensitive to the market all the time. So here the company has been in the violation of the rule, as can be seen from the factor that Mr. Shaw has transferred a sum of $7.5 million of his Australian to his account of China. So this could be price sensitive information that he was trying to take the entire cash of the company to his personal account in China. So he did not disclose this transaction for the reason to the transaction with the market related to provide the loan to China based subsidiary. Thus, the application of Rules 7 to 8, 1A and C show the company is a gross violation of the rules as it has been misleading the information of the prospectus. Thus, the material emission in the prospectus and the same can be seen from the fact that company has misled the parents with Chinese subsidiary and has performed profitability of business, and as well as both of the information was true. I will continue my part, which is conclusion. The court has evaluated the case on the basis of rule under the section 674, 72, 8, 1 and 3. The first thing that the court have ruled out was that the Mr. Shaw has made false representation in the prospectus documents of IPO filing. These false statements were regarding a patent that he had claimed were held by the China-based subsidiary. Further, court observed that Mr. Shaw had failed to disclose that company has loan agreement with China-based subsidiary where he is the sale director. Court also observed that Mr. Shaw had misleading and deceiving statement in the prospectus documents with the regard to service contracts. Mr. Shaw had claimed that the whole service contract in China, and court has also found that he has made the false claim that the company has received $3.5 million from the sale of convertible notes. This information was found to be untrue in the court law. Court has also found several counts where he had provided false information to the auditors regarding the China-based subsidiary. He did not fulfill his duty and he failed to disclose crucial information in prospectus. He has also tried to transfer a sum of $7.5 million from his Australian account to his account in China. This money was transferred to provide a loan to China-based subsidiary. The circumstances were such that this loan would have not recovered. That was my part. Thank you very much. Bye.